Today's topic on the Legal Minute: how does bankruptcy work? In a Chapter 7 or liquidation bankruptcy, you file a petition with the bankruptcy district in your state. Your petition includes all your biographical information, income and expense information, and lists of your assets and debts. Approximately 4 to 6 weeks after you file your petition, a 341 meeting of creditors is held. And this is a chance for the bankruptcy trustee, as well as any of your creditors, to show up and ask you questions under oath about your bankruptcy paperwork. Normally, creditors don't show up, but the bankruptcy trustee will at least have a few questions. While they can last pretty long, the average is usually only 5 to 10 minutes. And it's only about paperwork that you've submitted that they have questions about. Approximately 2 to 3 months after your creditors meeting, you'll receive a discharge in the mail, and that discharge is your legal document which legally prevents you from having to pay all of those debts that were listed in your petition. Contrary to popular belief, you do not have to give up everything you own when you file bankruptcy. There's something called exemptions in a bankruptcy, which allow you to keep certain property. For instance, if you own a home in the state of Nevada, you can keep up to $550,000 of equity in your home. You're entitled to one car with up to $15,000 in equity. You're entitled to $12,000 in household goods. So you do not have to give up everything when you file bankruptcy. You get to keep the basic things that you have to live on. If you wish to keep a house, a car, or any other asset secured by a lien, or an unsecured debt such as a credit card, you can do that in a bankruptcy utilizing a reaffirmation agreement. That's an agreement between you and your creditor where you'll pay your balance in full, but you get to keep the asset, such as your house or your car. You should also take notice that some debts, such as student loans or income taxes, may not be dischargeable in bankruptcy. In order to qualify for a Chapter 7 bankruptcy or liquidation bankruptcy, you have to pass something called the means test. And a means test is a measure of your income and the number of dependents you have versus the cost of living in your state, city, or region. Your bankruptcy attorney will be able to tell you the exact amount in dollars that you're able to make and still be able to file a Chapter 7 bankruptcy. In a Chapter 13 bankruptcy, also known as a reorganization or repayment bankruptcy, a plan is formulated where you pay a certain percentage of your debts to the bankruptcy trustee or directly to creditors over 3 to 5 years. The advantage of a Chapter 13 bankruptcy, however, is that it lets you do some things that you can't do in a Chapter 7 bankruptcy. For example, if you own a home that has, let's say, 3 mortgages, under a Chapter 7 bankruptcy, you have to reaffirm the full balance on all 3 mortgages. Under a Chapter 13 bankruptcy, assuming other conditions are met, you can actually discharge your second and third mortgages. They become unsecured creditors just like a credit card. You do still have to pay the full amount on your first mortgage, however. If you have a car that's underwater, which many people do, if your car is worth $15,000 and you owe $30,000, they can do something called a cram down. And you're going to pay through the bankruptcy plan only the $15,000 the car is actually worth. The remaining $15,000 balance is considered unsecured debt, just like a credit card. Chapter 13 bankruptcies are more complex and more expensive than a Chapter 7. Only a bankruptcy attorney licensed to practice in your state can tell you what would be best for your individual situation. My name is John Cereso. I'm with the Nevada Law Group. And if you'd like to comment or ask questions, feel free to visit our website, www.nevadalawgroup.com. This has been the Legal Minute.